Good morning or afternoon, depending where you are. Welcome to today's webinar, 280E updates, rescheduling, amending returns, and why timing matters. Thank you all so much for joining us. If this were a live conference room, we would be standing room only. We have a packed house. I'm Noelle Skidinski with Cannabis Business Times, and I'm going to keep my intro very short today because our speakers have a lot of really important information to get to in a very short amount of time. So I want to first thank Calyx CPA for making this webinar possible. Calyx, headquartered in Southern Oregon, is a boutique tax and accounting firm specializing in the unique needs of plant medicine companies. It provides solutions to effectively mitigate the impact of 280E and offers comprehensive business consulting, entity advisory, tax planning, and tax preparation to companies across the U.S. Before we begin, I have a few quick housekeeping notes. We are going to try to leave time at the end of the webinar for the live Q&A. So attendees, you can submit your questions at any time during the webinar. If you would do so using the Q&A box, not the chat window. The chat is turned off, so you won't be able to chat with other attendees. So you should see a box with a question mark in it, and it should say Q&A at the bottom of your screen. If you don't see that, there should be a more button with 3 dots, and if you click that, you should see the little Q&A box in there. Click that and submit your question that way if you would. Our speakers also have graciously offered to follow up with any questions we don't have time to get to live, so they will follow up with you via email. So if you have any technical questions, you can communicate with us using the chat feature. You can put them in the Q&A if it's easier, wherever you want. We'll be keeping an eye on that. And we will be recording the webinar, and then we usually, probably within a day or two, usually within a few days maximum, we'll be sending a link out to all of you with the recorded webinar. So you don't have to worry about it. You can go back and view it again if you would like. With that, I am pleased to introduce our speakers today. Justin Bautier, the CEO of Calyx CPA LLC. With more than 20 years of experience advising business owners, he has developed a national practice focused on cannabis accounting, tax strategy, and Internal Revenue Code Section 280E, the topic of the day. Before recreational legalization, Justin was among the first accounting professionals to advocate publicly for cannabis operators. In 2016, he sold his general accounting practice to focus exclusively on the cannabis industry. Today, he advises cannabis operators across the country on aggressive but defensible strategies for challenging the impact of 280E. And his experience working with thousands of business owners and cannabis companies allows him to provide high-level guidance on entity structure, business growth, tax strategy, and the complexities of operating in a highly regulated industry. I'm also pleased to welcome Jamie Jorgenstone. Jamie is a CPA, tax strategist, and chief technical officer at Calyx CPA, where she advises cannabis and emerging plant medicine businesses on complex tax matters. As a founding partner of Calyx, Jamie has helped develop a national practice focused on cannabis accounting, tax strategy, and aggressive but defensible tax positions. That word is very difficult, defensible. I feel like I'm putting the wrong letter in there. Her work emphasizes in-depth technical analysis, opportunities found in underutilized areas of the tax code, and the use of sophisticated tax and business strategies to mitigate exposure in highly scrutinized industries. So with that, I am done, and I'm very pleased to welcome our speakers and turn things over to Justin. Welcome.
Thank you very much. Thank you for that introduction. That was pretty comprehensive, so much appreciated. So this is a presentation that I've done a few times. Jamie and I regularly collaborate on it. I have a slide deck that I'm going to share. It's pretty comprehensive, and ordinarily I would try to go from the beginning to the end to cram as much information for you to peruse after the recording is finished. You could re-listen to it, but we're not going to do that this time. Kind of last minute, we decided, you know what, we need to focus on the current events, and we need to give people more time to ask questions. And so that's what I'm hoping we're going to be able to do today. And speaking of questions, Nicole, we already have a question. Will the printed material, if any, be distributed? And so I'm not sure if you have access to the slide deck now or if it's something we will need to follow up with you, but we will provide that slide deck one way or another. And unfortunately, the printed one that we have is already outdated because things are transpiring so fast that even from the time that we said we were going to do this presentation to now, things have changed substantially. So, so the main things that we're going to want to start on, we're going to talk about today are, of course, the rescheduling, the medical marijuana rescheduling that happened in April, and the status of that because it still is pending. It's not absolutely done. Then, of course, we've got the New Mexico Top Organics case. That's the court case that we've been watching very closely. It's the one in which the plaintiffs, New Mexico Ultra Health, is challenging the statutory language or the interpretation of the statutory language of 280E, which is essentially the ammunition that the industry is using from, all the way the biggest companies like True Leaves and Canada Provisions and many of these companies that are refusing to pay tax on phantom income. They're amending tax returns, getting their refunds. And that is a big part of the New Mexico Top Organics case is a big part of that. And then, of course, the broader rescheduling efforts, the adult use cannabis. So as you know, in April, the Attorney General rescheduled medical marijuana. Well, now there's been some administrative hearings considering the rescheduling of recreational marijuana or the rest of the industry. And so we have some updates for you there as well. So with that said, I'm going to share my screen here. Okay. Hang on one second. I just want to make sure that I can see. All right. So again, like I said, we're starting where we are now. And before, okay, so I'm going to go back just a little bit because what does it mean where we are now? Well, where we are now is only because where we have been, and the journey has been long and bumpy, and so many things in the last couple of decades have transpired in the cannabis industry, and then accountants like us have been doing everything that we can to help our clients pay a reasonable amount of tax because, as you know, 280E is absolutely detrimental. And so we are assuming that our audience does know what 280E is. We're assuming that you're hopefully working with an accountant that has some sort of specialization knowledge in the cannabis industry. They're working with other code sections like 471C to at least attempt to mitigate your tax consequences. But that is now somewhat in the past. 471C is conservative method to mitigate 280E. It can be leveraged based on your risk tolerance to include otherwise disallowed deductions, a lot of them, or as little, depending on what your risk tolerance is. I highly recommend you use an accountant that has a little bit more of a stomach for risk because 471C can be leveraged and it can really help bring your tax liability down to near legal levels if done properly with the proper disclosures and whatnot. That is still being used, but now we've entered a new era, the new era of do we even need to pay tax on or proactively pay tax on phantom income? And that kind of kicked off with the HHS letter recommendation to the DEA backed by 250-page FDA paper that clearly stated that cannabis does not fit the criteria of a Schedule 1 substance. It solidly fits the criteria of a Schedule 3 substance. And when that happened, all of a sudden, True Leaf shortly after got $114 million worth of refunds. And as of January, so like as of the end of last year, according to the information we have access to, which is is available via the internet. If you Google it, Marijuana Business Daily did a great article back in March talking about how there was $1.6 billion of uncertain tax on the balance sheets of these large MSOs, and including Trulieve, which had at that time saying that they are not paying tax on $600 million. And so then there's a bunch of other of the large companies that are filing their tax returns without proactively paying tax on this phantom income, and instead that potential liability is sitting on their balance sheet. So that's kind of important to know. It's like, well, if they're doing it, why can't we do it? So we will talk a little bit more about that. I don't want to get too far off topic. So of course, in April, we got the announcement that the Attorney General decided to reschedule medical marijuana, meaning state licensed company or state license, medical state licenses. And that is now a Schedule 3 substance, which is fantastic. At that time, the IRS said that they will issue guidance as to what that means, but we are still waiting for that guidance. So, but it is safe to assume that if you are operating in a state in which, and you have a medical license exclusively, then you are no longer subject to 280E, which is fantastic. Unfortunately, there's a little bit of ambiguity about, okay, well, if I'm in an adult use state and I have both adult use and medical, what does that mean for us? Am I allowed to take my deductions or am I not allowed to take my deductions? And then, of course, the vast majority of the United States still is in an adult use license states, and most of the operating income comes from that. So those people, unfortunately, are still in the 280E applies for them. Jamie, I don't want to take all the airtime, but you felt like it was important to talk a little bit about the details of how this is actually being challenged, which I think is a good idea. And if you
Yeah.
talk a little bit about it.
Yeah, so a little more context about the rescheduling is there's a couple different avenues to reschedule a substance. And so medical marijuana was rescheduled using kind of an exception to the normal avenue. And that's the Attorney General has the authority to schedule a substance to keep the US in compliance with its treaty obligations. And so the acting attorney general leaned on that authority in order to just immediately reschedule medical marijuana, kind of like on the spot in April. And that was bypassing this normal process that we're kind of used to, which is what's happening now with like the broader rescheduling of marijuana as a whole, including adult use. And I think that's important because one, of course, it's like bifurcating the industry, right? So now there's medical and there's adult use, and there's always been kind of different arguments or stronger, slightly stronger arguments for the medical world than the adult use world, in the long history of that Justin was referring to earlier. But this, of course, makes the argument for medical marijuana really, really strong, at least as of the date of this order, that 280E no longer applies, right? And then that kind of leaves adult use just hanging, right? So now what does adult use do? And I think some people might argue now adult use has kind of a weaker position because medical marijuana was specifically kind of called out and bifurcated, and then adult use would still be lingering in Schedule 1 with all those limitations. But I think it's important to note that the way that medical marijuana was rescheduled is being challenged in the courts right now. There's, a group of people who believe that the Attorney General overstepped by using that authority, and it wasn't like a proper use of this treaty exception, and that there is a chance that it could be stayed. That's what the parties have asked, that the order is stayed, meaning it's basically like becomes inactive for a while until the courts can hear the arguments. And I think that's important because it's so odd, right? Like we rescheduled medical marijuana right away, and they just kind of got this head start. And then now we're waiting for the normal process to take place. It's happening right now, that normal process where we do the hearings, where we listen to the evidence, and that's happening now. So that would include medical marijuana. The broader rescheduling would include medical and rec. And so I think we need to remember that adult use isn't just out of luck here, right? And I think there still is a strong argument. And I think the arguments for not applying 280E to adult use operators are still very strong and getting stronger by the minute. And medical marijuana being ahead of the game, may ultimately not be allowed.
Hey, Jamie.
Yeah.
So we already have some questions, and we do want to encourage people to ask questions because we want to definitely steer the conversations towards the questions that people have and not just make assumptions about what people want to hear. And so one of the questions is applicable to this subject, and she's just asking, do medical cannabis businesses need to continue to do cost accounting? And then she asked about, and when does that apply? I'm gonna go ahead and say we're gonna answer these live. And so first of all, yeah, if you're a medical only business, like you're only licensed medically, which a lot of states only have a medical license, and so that makes it very, very clear cut. Rescheduling happened in April of 2026. The IRS's guidance indicated that it would be retroactive to the 1st of 2026. So 280E no longer applies to you. So you can go back to your uncle who did your tax returns before, and it should be fine. You should be able to file your tax returns like a legal business, any other legal business. The difficult part is when you have adult use sales and medical sales. And Jamie, forgive me if I'm wrong, but it's my understanding, I mean, there wasn't really any guidance so far on, okay, well, does 280 apply to my business? If I have both adult use sales and medical sales, does 280E still apply? And the answer I can only assume would be yes, it does. And if the IRS were to provide guidance, they would say, well, your expenses that are associated with your adult use sales would be disallowed, and then the expenses that were associated with your medical sales would be allowed. So there's like this bifurcation, like Jamie said. Did the IRS actually come out and say that? I can't
Yeah, they
remember.
sort of said that. So
They
like
sort of said
pretty
that.
immediately after the order, I think maybe the next day, they issued preliminary guidance that was very vague, very high level. And they said most likely, I don't think it's official, but most likely the 280E would not apply to the beginning of the first tax year that this rescheduling happened in. So for most taxpayers, that means, as you mentioned, January 1st. So not, because that was a question and that was specifically asked here. Is it from April 22nd forward that 280E doesn't apply, or is it from January 1st? Most likely January 1st. They're probably not going to nitpick that date. And that would be 2026. So, right now, many people are filing their 2025 tax returns. According to the IRS, as it stands right now, it would be 2026 going forward, not 2025.
Right, right. Yeah.
So, and then they said they would basically provide guidance on, yeah, how to allocate, but they would be expecting you to allocate your adult use and your medical and somehow, allocate those expenses. And that's what we're waiting for like official guidance on. They said they would be giving it and they haven't given us
They
anything.
haven't done that. And we'll kind of touch on what, touch on why that's important, that guidance, and as they don't provide guidance, how that is somewhat detrimental to you. Um, and then I wanted to talk about like how even this has given this rescheduling of medical marijuana has given the cannabis industry a potential window again, even for the adult use, to potentially again not proactively pay tax on phantom income by applying 280E because, you know, I have done a lot of thinking about this and talked with other cannabis accounting professionals, and we kind of agree that what about the states that have both medical and adult use? Like, so we're in Oregon, and what's interesting about Oregon is that the same processing or the same compliance requirements apply to both the medical and the adult use market. And shops, as long as they have a medical endorsement, can sell medical marijuana in them. But where they source that product from, for example, maybe there is a farm that produces medical cannabis and does the testing and the packaging and everything, and then the retailer buys that product, or maybe it's a combination. Maybe it's a farm that has both adult use and has a medical endorsement, but the product is still processed the same. It's tested the same. It's packaged the same. Then it goes to the dispensary. Now, if what the IRS is essentially saying is that it depends on whether or not the customer has a medical card or not. So how can they say if a customer comes into the dispensary and buys the same product, if they have a medical card, then all of a sudden that product is a Schedule 3 substance. But if they don't have a medical card, it's a Schedule 1 substance. How does that work? I don't know if I'm being very clear, but essentially what I'm saying is if if they try to base whether or not 280E applies on the gross sales, what if it's the same product, but if somebody with a medical card buys it, then it's Schedule 3, or if somebody buys it and doesn't have a medical card, it's considered Schedule, and that doesn't make any sense. That's what I'm trying
Yeah,
to get
so
to.
so I think just to clarify a little bit, Justin,
Yes. Thank you. That's why I have you here,
I
Jamie. Thank you for
think
clarifying.
so one way and what I think many accountants anticipate is the likely guidance we'll receive is that a taxpayer can take their medical sales and versus their adult use sales and use those figures to create like a percentage, and then that would be what you apply to your expenses to determine what percent is allowed and what percent is disallowed with regard to 280E. And so, Justin, your argument is that doesn't really make any sense because the category of the sale is just based on the end user, not based on the product itself. And
Yeah.
so the product itself, there's no difference. And so why would 280E apply to this product sometimes and not other times? That's a great question.
And perhaps it's a mute point because if ultimately the adult use gets rescheduled in 2026 and there is no difference between medical and rec, then
Mm.
then it doesn't matter. That actually doesn't matter. So
Yeah, and
interesting.
so we have several questions now
Yes.
about medical only operators amending tax returns. And so I want
Do we
to
want to
just,
talk about those a little bit later
do we want
after
to, yeah.
we may not want
Well,
to
let me
skip
say
straight to
one
amending.
thing. There's
Okay.
no formal approval right now by the Treasury or the IRS to allow you to amend tax returns for prior years at this point. The IRS has not agreed with that position. The Treasury hasn't issued any guidance. The order, the rescheduling order, referenced potential retroactive treatment of not applying 280E, basically. But the Attorney General was urging the Treasury to allow that type of thing, so that, basically allow amended returns. But the Treasury is the one that ultimately gets to decide. So that's really good ammo for attempting an amendment, but it's not a surefire thing. And so I think we'll get into kind of the adult use situation, and the same arguments would apply, and even a little bit stronger to medical for potentially amending. It's kind of a choice right now.
Yeah, and
So,
that is amendments are a big topic of that we're going to cover.
yeah.
So there was a lot of questions for that.
Yeah.
Okay. Well, let's talk about broader marijuana rescheduling efforts. Jamie, do you want to kick this off?
Yeah, sure. So we had the administrative hearings. They concluded on July 15th. Since then, the participants have been drafting their post-hearing briefs, and so those were submitted. They're optional, but quite a few were submitted. Those were submitted on August 17th. They're pretty hefty. It was several hundred pages of briefs. And then just I think yesterday, the official transcripts were released, so of the hearings. So now the public can review those, can peruse them when they have all the time in the world. I think it was like 2,000 pages of transcripts or something like that. And so we're moving along with broader marijuana rescheduling. Now, though, the administrative law judge has to review the entire record, review everything, review the briefs, and ultimately make their recommended decision, make a recommendation on whether they recommend marijuana be rescheduled or not, or to a different schedule, right? So the DEA in this rescheduling process, the DEA is pushing for marijuana to be rescheduled from 1 to 3 as a whole. All of marijuana be rescheduled.
Jamie,
Yeah.
not to interrupt, but okay, no, actually go ahead and then I'll interrupt you later.
Okay.
Sorry, continue.
So the process is now we're waiting for the judge to make the recommendation, and then the DEA ultimately gets to decide, make a final decision, which is kind of interesting. So I don't know if everybody's aware of that, but the judge doesn't get the final say. They make a recommendation, and then the DEA gets the final say. And so. Yeah, I mean it's pretty cool reading the briefs. The DEA is arguing that marijuana does not fit the statutory requirements to be a Schedule 1 drug, which is great news for New Mexico Top Organics, for example, who is arguing the same thing. They're arguing that 280E doesn't apply because marijuana doesn't fit those statutory requirements. And so it's pretty cool to get the DEA on record saying that. I mean, that really strengthens the arguments and the positions, the no 280E tax positions. I think it's it strengthens those positions a lot.
So for the audience, if you're asking questions, you need to put it in the questions and answers. The chat, we can see the questions, but then we can't make those public, and we're not watching the chat window. So you want to ask your questions in the question and answers. Yeah, I'm just going to read. Can I read a little bit from the DEA final brief?
Yeah, that's a great idea.
I mean, I just think it's great because it sounds like what we've been saying for years. And then here it is, the DEA, the government itself, finally getting intellectually logical, right? Finally they're catching up with logic. I just like it. So the introduction, the government comes before this tribunal in support of its position that marijuana, as defined by the CSA, should be transferred from its current placement in Schedule 1 of a Controlled Substances Act to Schedule 3 on the basis that marijuana no longer fits two of the three statutory requirements to remain in Schedule 1. I love how it says marijuana no longer fits two of the three statutory requirements, as if somehow when Trump signed that executive order and the Attorney General got on board, now cannabis has medical use and is not dangerous and isn't highly addictive, right? So I
Justin,
just find that interesting.
do you want us to be able to see it? We can't see your screen if you wanted everybody to be able
Oh,
to see it.
okay.
We're just seeing the
Oh,
slides.
okay. Yeah. Well, let me do that.
I don't know if you wanted it or not, but
Well, I'll have to. We could take a moment. Okay. So here it is. Okay, so this is the government's proposed finding of fact and conclusions of the law. And I just read this part right here. The government presents to this tribunal the 2023 recommendation from the Department of Health and Human Services that marijuana be moved from Schedule 1 to Schedule 3, fact and expert testimony and legal arguments. So really, I mean, that's all I really wanted to share is that we have been saying for quite some time that cannabis doesn't fit the criteria of a Schedule 1 substance, especially once the HHS had, had wrote that letter. And then there is a question about when did this administrative process uh, take place, and is what's happening now an extension of what Biden had started, or is this process a new hearing? And the question that I have is, shouldn't this have been concluded the first time in 2023? In 2023, in regard to the administrative hearings that kind of stalled out and then ended up just being indefinitely paused until now, 2026, is should this have been concluded in 2023? Now, I don't know, Jamie, you can't necessarily answer that question, but I hope it's something that an attorney or attorneys ask and scrutinize, like when the HHS wrote that letter and those administrative hearings took place back in 2023, shouldn't the decision have been pushed through, or at least taken to the end, similar to what is happening now? And if that had happened, then we would have a different outcome. So anyway, that's a thought that I had.
Mhm. Yeah, and so just to expand a little on that question too. So the question was, are we further along than under Biden on that process, or do we just restart the same process? We are further along at this point than the Biden process ever got. This administration actually like scrapped the last process and kind of reinitiated it is what happened. But at this point, we've actually gotten through the hearings, and now we're getting to the point where the judge is actually going to make a recommendation. And so we're further along, but yes, it kind of was just restarting the same process. Um, okay, so should we go to New Mexico top organics?
Yes. Yeah, we probably should start to hustle though, because now I think I
I
was
know.
too
Yeah.
long-winded. I
Yeah.
apologize.
No, I think it's been great. So, New Mexico Top Organics, this is the tax court case that was initiated in late 2024 and kind of got going in 2025. And this is a taxpayer challenging the IRS's interpretation of Section 280, Code Section 280E. And so 280E's language, which 280E is the code section that doesn't allow cannabis operators to expense or take their overhead deductions on their tax return. And so that creates what we refer to as phantom income, right? Their taxable income is higher than their actual income. And so 280E says that it applies to businesses trafficking a Schedule 1 or 2 substance within the meaning of the Controlled Substance Act. So that language is what this whole tax court case revolves around. So the taxpayer is saying the correct interpretation of the words within the meaning refers to like the definitional criteria of a Schedule 1 substance or Schedule 2 substance, right? So not looking to what is actually currently listed as a Schedule 1 substance, but whether or not that substance actually meets the criteria for a Schedule 1 or 2 substance. Okay, and the IRS disagrees, right? The IRS's position is if it's listed as Schedule 1 or 2, then 280E applies. And then the taxpayer is saying, well, actually, that's not the way it should be interpreted. We have the HHS saying that recommending that cannabis be rescheduled, and that's really good evidence that cannabis does not meet the definition of a Schedule 1 or 2 substance. Okay. So that tax court case, like I said, has been going on. In 2025, there were lots of briefs back and forth. We thought we were going to see kind of more progress on the case, but then in April, the rescheduling order happened, and all of this rescheduling process started, and that is directly related to the arguments here. And so then now the IRS and the taxpayer have to go back and forth arguing about how the current events impact their case. And what's really important about New Mexico Top Organics is it's asking the courts to like whether 280E applied back in 2017, 2018, and 2019. So a lot of the evidence we have is like 2023 and moving forward. And there are really good legal positions and tax positions as to why those same arguments apply more retroactively. However, this court case is asking the courts to decide that. So it's very relevant to the position. So the IRS just replied, just issued another brief in at the end of July, and then the taxpayer responded just a couple days ago, but we haven't been able to access that document yet. It's not publicly available for some reason. But really the point is that the argument just kind of rages on. The IRS continues to say, we think 280E applies to any substance that is currently listed in Schedule 1 or 2. And then the taxpayer continues to say, we don't think that's the right interpretation. And ultimately, the courts will decide which is which.
Yeah, and the debate is definitely raging on. It is, it has felt very clear to me that we were on the right side of history in terms of the statutory language of 280E and the HHS saying that it doesn't meet the definition of a Schedule 1 substance, and therefore, according to the language of 280E, 280E shouldn't apply to the cannabis because it doesn't fit the meaning. But the IRS does have good arguments for why we're wrong in that way. And it's still a 50-50. I was talking to an associate, they were saying, hey, I have experience with court cases, and it's like you might have a really open and shut case, a really good argument, and it makes a lot of sense to you, and it's very logical, and then the court's like rules in the opponent's favor. And you're like, whoa, how did that happen? At the same time, they've seen arguments where they had a really shoddy argument. They had a shoddy case, but yet the tax, or not the tax court, but the judge ruled in the favor of the plaintiff. So it really is a 50-50 type of situation still going on.
And it's incredibly just complex and nuanced, right? The long history, courts weigh all the past court decisions and all the different, the different parts of the argument. And it's not usually just so simple as here's a logical argument. There's a lot more to it. And so, but there is a very strong argument for both sides. And I think that's the really important piece. And that's what kind of leads us into the burning question for everybody is, can we amend our returns, and do we have to continue to apply 280E? And I think the answer is it really just depends on your personal risk tolerance. And so what Calyx does, and what we're here to hopefully educate people on, is that taxpayers have a choice, right, of whether they apply to ADE right now or not. And you can choose not to apply to ADE, and you can choose to amend your tax returns, and do so in a way that where you're still protected. You're not filing a fraudulent return. You have a position that it's called a reasonable basis to take a position. And that protects you from penalties for taking the position. It doesn't guarantee the success of the position, right? We know that the IRS's official stance right now is that 280E does apply. But the reality of the situation is that there are lots of taxpayers, including these really large MSOs, that have, ahead of the official guidance by the IRS, the official green flag, they have been filing amended returns, and they have been receiving refunds, and they have been moving forward since 2023 without applying 280E on their tax returns, and therefore not paying that additional tax. And that's where Justin mentioned earlier, reports came out near the beginning of this year that I think it's just like 5 of the largest MSOs have a collective $1.6 billion of basically taxes they've chosen not to pay, that relate to 280E. So that's these big MSOs saying, we don't think 280E applies, and they have thus far not had to pay those taxes back. And it continues to unfold, right? So taxpayers right now can amend returns. Many are doing so, but there's not a guarantee that that return will, be successful ultimately, will be accepted by the IRS, will get you a refund, or reduce an outstanding liability you may have. That's not a guarantee, but there have been a lot of taxpayers that have been successful thus far. And so then the question becomes, what are the risks of filing the tax return? So Justin, maybe do you want to go to the next
Sure.
one? I think
And
that's great.
I did want to mention that if you guys want to hear more about the New Mexico Top Organics case, because we did a webinar that was specifically for that, kind of going down, like totally breaking it down into the pieces. And then there was the follow-up briefs, the amicus curiae, what they call them, which was really compelling in terms of the arguments why this was, what did Jennifer Benda put it again? Intellectually, what was the word?
Dishonest.
What?
Intellectually dishonest.
Intellectually dishonest. I loved it. I loved reading that. And so you can go to our YouTube channel, and then if you guys want to help us, you could like Calix's YouTube channel because my kids say that I don't have enough followers or whatever, and it's embarrassing. Anyway, just a thought. Okay, so let's
Um,
see.
there is a question here. Oops, I hit my microphone. There is
Yeah.
a question here about the estimated revenue generated for the federal government from 280E. That's a really interesting question. So I think it was in maybe last year or early this year, there was a study published that said since 2018, there's an estimated $15 billion that the federal government has generated just on the taxes paid relating to 280E, so in
And that's
excess
probably an
taxes.
understatement, I
And that's
think.
probably an understatement. And 2018 was the first year that 471C was available to taxpayers. So prior to 2018, those amounts were much higher, most likely. Like relatively each tax year, the 280E hit was bigger. And so the amount is very large. And that is one reason why I think taxpayers should be prepared for the IRS or the Treasury to not officially allow amending returns, right? I think it would be kind of impractical for them to allow that because it's such a large amount of money. Where's that money going to come from?
Yeah, I think they're going to try to kick the can, like before they give us relief, retroactive relief. It's probably going to take a tax court case. It's probably going to be like New Mexico Top Organics applies to medical, potentially winning medical businesses retroactive relief if it succeeds. Okay. If it doesn't, the IRS is very unlikely going to allow retroactive relief, except for maybe a few years, potentially due to the Attorney General urging the Treasury Secretary to allow for retroactive relief. We don't know until we see the guidance. But New Mexico is going to have to win that case in order to get their money from 2018. At this point, you are not allowed to amend your returns and get those refunds. You can attempt it, and other companies, big companies, there's a lot of accountants, a lot of tax attorneys amending returns, writing opinions, getting people refunds. It's just that the success of getting those refunds is not guaranteed. Shoot, I was about to say, we have another case. Do medical companies, cultivators, manufacturers, dispensaries have to register with the DEA to not apply 280E? That was one of the other things that came up with the rescheduling, is that the DEA is creating a federal program essentially where you as a medical licensee can now go try to get a DEA license, which is the only way you're going to be federally legal, because just because cannabis is now Schedule 3 doesn't mean you're federally legal. At some point, if you're going to participate in the DEA's program and you want to become federally legal, you will have to get a license from the DEA. That's the only way you'll be federally legal. However, 280E does not apply to you if you are a medical licensed operator. Okay, so 280 does not apply as of 2026.
Yeah, you even if you haven't registered with a DEA,
Even if you
280E
haven't
doesn't
registered.
apply.
It's just that you're not going to get the benefits of being a, it's kind of like pharmacies have to get a DEA license in order to prescribe subscriptions or fulfill subscriptions. That's kind of what they're like looking to do. And maybe there's an interstate commerce aspect of it. Maybe there's an export import potential there. But right now, for the vast majority of the cannabis industry, it's just status quo. The only benefit of rescheduling is that 280 doesn't apply to you.
Yeah, what you do need is to actually have an active medical and like medical license, right? State issued medical license. There are at least a couple states that have come out saying that you won't be in compliance with their medical licensing kind of apparatus anymore unless you do register. So there are some states that are requiring DEA registrations to keep your state issued medical license. And so that will kind of depend state to state. But you do need to have that, an active and theoretically in compliance state issued medical license in order for 280E not to apply officially, as of right now. That could change depending on if we, get a decision on the rescheduling, the broader rescheduling of marijuana, which a lot of people are anticipating before the end of 2026, but we really don't have any strict timeline for that. There's no timeline requirement for that, which is kind of an interesting point we glossed over earlier, which is the administrative law judge now makes its recommendation. That will hopefully come quickly, but it historically can take a year or two for the judge to make the recommendation. And it can also take a year or two for the DEA to ultimately make its final decision. So people are eager and hopeful that we're going to get a rescheduling decision by the end of 2026, but we don't know that for sure.
Yeah, do we want to go over? I think there's some confusion about amending because again, so far the IRS is not allowing amendments, but there are companies that are willing to be aggressive and proactively amend. And we have a reasonable basis to do that with the assumption that there will be some sort of determination, some sort of relief eventually. Now, you have to understand that once you amend a return, once they give you a refund, there is a statute of limitation for the IRS to come and try to claw that back from you. And so that's how like TrueLeave, they amended their returns. They got $114 million back. A lot of those for specific years going back to, I think 2019, maybe was it? I can't quite remember. And those statutes for the IRS to audit them and to try to claw that money back is over essentially. And the IRS they're going to get to keep their money ultimately. And then there's proactively going forward without reducing deductions. Again, all of this, there is a risk to all of this. Like the IRS could come back and like try to make life difficult for you. So there is a risk. We personally, just us at Calyx, have not seen that happen yet. And we have a lot of other colleagues that are doing similar things, and we haven't seen a lot of pushback. The IRS is pushing back in some areas, but we haven't seen that, especially for small taxpayers, small business, what's considered small businesses and whatnot.
So I think the
Yeah.
statutes are important, and I think I want to
Yes.
talk a little bit about the various statutes of
Where were
limitation.
we?
Um, I don't know where it is
Yeah.
anymore,
There we go.
but
Go for
so
it.
there's several kind of timelines that need to be considered when you're thinking about, do you want to amend your return? And then also when you're thinking about the risks associated with amending your return or filing an original return without applying 280E. And so the first is that a taxpayer generally has, and there's nuances, but we're going to speak in general terms here, generally has 3 years from the date that they filed an original tax return to go back and amend it. And separately, but similarly, the IRS generally has 3 years from the date that return was filed to assess additional tax. And that's usually done via like an audit. Um, and so and so the reason that it's important that taxpayers right now stay informed is that each year, if you're not taking some action on these past tax years that have already been filed, each year you're losing the ability to go back and kind of recapture or reclaim deductions you may have disallowed or, attempt to get your money back in prior years because the statutes of limitations are going to be closing on those years. And so if you filed a timely return, so it wasn't late, this year the 2022 tax year is closing for taxpayers if they filed timely because they would have filed that return in tax year 20 or in the financial year 2023. And so 3 years from that is 2026. And so if you haven't filed either what's called a protective claim for refund or gone back and filed an amended return, a legitimate amended return for those years asking for a refund or a reduction in tax, you're going to lose the ability to do that, even if we get guidance later that says you should be allowed to do that. That guidance isn't going to override these statutes. These statutes of limitations just say you can't go back more than 3 years. And so the way to preserve your statutes are one, to either just go ahead and file an amended return, get it in before the statutes close, and then there's a whole process for kind of following up on that amended return. There's like kind of two ways it can go. Maybe you file an amended return and you get the refund. That's great. Maybe they deny it, and then there's an appeals process. Okay. So you can do that, or you can be more conservative and just file something called a protective claim for refund. And really all that does is it says there's some uncertainty here in the law. Usually it's based on an ongoing lawsuit that might affect my return for this year. And you're just saying, I want to keep my statute of limitations open for this year until it's resolved. And that will keep it open. And that's a great thing for taxpayers to consider. But the one issue will be unless you get final guidance, official guidance from the IRS or the Treasury at some point that says, yes, you can absolutely do this. You can go back and amend your returns. You're not going to get really the benefit of that protective claim. So choosing to amend now is a risk because it could be denied, but there's a big benefit, which is you may get your money now. You file the tax return, you present your position very clearly, and you have to disclose it. You say, hey, I'm filing this tax return. I don't agree with how the IRS interprets 280E, so I'm not applying it to this tax return. You say that all very transparently on the tax return, and you submit it, and you hope that it's accepted. So that's an option for taxpayers. Then there are statutes for after that return is processed. So let's say your return is processed, accepted, and you get a refund issued. The IRS only has 2 years to come back to you and say, now I actually think that refund should not have been issued to you. We think there was an error. And now I'm going to claw that refund. I'm going to attempt to claw that refund back. And they're going to say, I want it back. Give the money back to me. And then as a taxpayer, you have a decision. You can just give the money back if you want, or you can say, no, I believe that I am deserving of this refund, and you go to court. The IRS has to sue you to get the money back, and you defend it in court. Um, and then, kind of similarly to that, but again, separate, if they deny your amended return and say, actually, we do think 280E applies, we're not going to accept this amendment, you have 2 years as a taxpayer to kind of appeal that decision and ultimately file suit and sue the IRS to reconsider. So sorry, that was kind of long-winded, but those are important statutes to remember. And they all relate to the risks associated, right? So if you get your refund, then you have 2 years. And then if the 2 years is over and you got your refund, your risk is at this point, effectively gone. Like they didn't claw it back and they lost their ability to do that.
Yeah, so a lot of people, a lot of people like warn not to be proactive in trying to get the refunds because of the fear of penalty and and making a mess. That's what they're always like, what was it? Like reckless. That's what I see everybody saying. It's
Reckless. Yeah.
reckless
Hmm.
to do this. And again, it is a risk, but it is not. This isn't speculative. It's not frivolous. So therefore, if done properly, you can be protected. So far, most of the amendments we've done have come back positively. Some of them do get denied, where the IRS is just like, we're not going to process this. In which case, there are ways to keep the statutes open. There's an appeals process. There is a Form 907 that we could get signed by the IRS. I have personally been working with an appeals agent that's said, yes, send me the 907 and we will get that signed, which gives us the opportunity to keep the statutes open, similar to a protective claim.
Yeah. From our experience, IRS agents are often willing to have, a conversation about things, and a reasonable conversation. And in fact, this appeals agent that Justin has been working with is really open to the conversation. They recognize that the law is evolving, that there's a lot of uncertainty, and that there is, a real legitimate position to be taken. And they're willing to work with taxpayers to kind of figure out how this is going to all play out. And so I do think that's important for people to remember. The IRS doesn't have to be just really scary. We don't have to be so scared of them. We can have an open conversation with them, but it does require, you being educated and knowledgeable and also transparent and not trying to hide anything. And that's a really important thing with these tax returns is I really want to hammer that home. If you're taking these positions, you have to be very above board with them and you have to be very clear what you're doing. And that's how you protect yourself as a taxpayer from, the biggest risk, which is the IRS trying to claim that you filed something fraudulently, or something along those lines.
Mhm. Um, So I think it would be good to also distinguish between cannabis and hemp. Hemp, if you're going through your state's like hemp program, then and you qualify, hemp is not subject to 280E. If you are licensed cannabis cultivator, processor, or retailer, you are subject to 280E, except if you're medical only. Remember, in 2026, if you're medical only, then you're not subject to 280E. But if you're mixed use at this point, you are. But hemp is a different animal completely, and that's a big conversation, a totally different conversation there. Let's
We're
see
kind of out
here.
of
I think
time,
we're
but I
kind
think
of
We have some more questions that I think we'll have
Yeah.
to follow up with. Um, yeah.
Yeah, we really hammered through a lot, and there's still a lot more to say.
Mm-hmm. Mm-hmm.
So again, you can probably visit us here. I'll go ahead and you can visit us at our website. You can you can contact us through it. You can watch other videos on YouTube that we have done. We've done this webinar multiple times. We do Q&A, frequent Q&As on these types of things. We will email you a reposting of this webinar, and we'll also probably invite you to attend another Q&A at another time.
Justin, did you want to share your email or anything, or we'll just follow up via email? We're going to send the
Sure.
link out with the webinar recording, and then you'll obviously, you said you would follow up with people who we didn't get to their questions today, and then also to do another Q&A on this, which is amazing. And I'm sure people greatly appreciate that because the questions keep coming in.
Yeah, you can email us at info@calyx.com. You can go to our website. There's a contact page. Again, I just recommend that maybe you visit our YouTube page, and there's a lot of videos there in terms of all of it. I did mention 471C for those people who don't want to move forward without reducing deductions for 280E. 471C has been a really reliable code section that we have leveraged to mitigate our clients' tax liabilities since it was passed in 2018. There's just so much. It's been a wild ride for sure.
It sure has. And Justin, I put the YouTube link to Calyx CPA's channel in for all attendees in the chat. So if anyone wants to grab that, you can just hop into the
Yeah, and
chat right now.
hopefully and is it one that I sent you? Because for some reason there's two Calyx CPAs, and one of them is outdated and doesn't have any videos on it. And then
It had a lot of videos. So
okay,
yeah,
that's probably it then. That's
yeah,
the
I'm
right
pretty
one.
sure
Thank
it's
you.
the right one. If not, we can send, we can put that in the follow-up email as well. Um, so yeah, thank you both. Thanks to Calyx CPA for bringing this webinar to us. Jamie, Justin, thank you so much for taking the time to talk with everyone and answer questions. It's going to be an interesting time to see how the New Mexico case plays out, and when hopefully all of marijuana is rescheduled, there'll be a lot more to talk about as well. So
Yeah.
thank you so much. And thank you everyone for joining us today.
Yeah. Thank you,
Yeah.
Noelle.
All
And
right.
thank you, everybody.
Thank you.
Thank you. Have a good day.
Bye-bye.